Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about the Liberal bail reform bill because in response to a lot of public pressure to really clamp down on bail, they've said we've brought a bail reform bill that's really going to tighten things up and it's really going to hammer down on repeat offenders and so forth. And they're really talking a big game about the impact this bill is going to have. Well, let's have a look at it because quite frankly, the impact this bill is going to have is very little. This is less about dramatic reforms to the bail system and more about trying to convince the public that they're doing something when they're really doing very little, if anything. So let's have a look at this. We'll go through it clause by clause and talk about what it does and what it doesn't do and where it's basically just purely misleading the public. All right, so this is Bill C-48, an act to amend the criminal code. And I'm going to skip over the summary and the preamble because those are basically just descriptions of what the bill does and why. The preamble is basically just a lot of platitudes. Whereas a proper functioning bail system is necessary to maintain confidence in the criminal justice system, including the administration of justice. Platitudes. So let's actually look at the amendments to the law to see what it does. So the first amendment that we've got here is this one. Whether the accused, so they're replacing paragraph 515 sub 3 sub b with whether the accused has been previously convicted of a criminal offense, including any offense in which the commission of violence was used, threatened, or attempted against any person. Now you'll notice that the last part there, the including any offense in which the commission of which violence, etc., 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 that part is underlined. And that's because that's what they're adding to this section. So previously, currently, it reads, whether the accused has been previously convicted of a criminal offense. All criminal offenses need to be considered. So when we add this thing saying including violent offenses, well, that was already included in the general category of criminal offenses. So this actually does nothing at all because there is no judge or justice on the planet that was not aware that violent offenses are in fact part of criminal offenses. And if there was such a judge or justice, they would probably be removed from the bench for being too addle-brained to function. This is purely smoke and mirrors. This is purely just something to tell the public that they've done something. And when we go back and look at the summary, they've said, require the court to consider if an accused person has any previous convictions involving violence. They've said that they're making a big change here, but the court already had to consider that as part of the general consideration of every previous conviction you have. So, yeah, this is just purely showmanship. The next thing they're doing is adding, and this is adding to the reverse onus provisions. Now, what is a reverse onus provision? Well, normally if you are, and I say normally, but there's actually so many reverse onus provisions now that in fact, most bail hearings that end up going to any sort of argument are reverse onus because there's just so many provisions that create reverse onus. But reverse onus is that normally, in theory, you would go to the court and the government would have to justify why you should be held in custody. To say, listen, this person has been charged with an offense, they're presumed innocent, and they have to convince the court that you should be held because normally you would be let go. Now, reverse onus actually kind of flips that and says, okay, you have to show why you should be released instead of that being sort of the default assumption. Now, this actually isn't such a big change in actual practice because sort of the tipping point doesn't move. It's really a question of who has the burden to bring the most evidence on that. And, who has the burden of persuasion and sort of which way you break a tie. So given that this is sort of a tie-breaking element, it really doesn't change things that dramatically. So what have they done here? Well, they've added some sections, and you can see once again from the underlining which sections they've added. Section 95, 98, 98.1, and 102 are now added to reverse onus provisions. So Section 95 is possession of a restricted or prohibited firearm together with ammunition. Well, okay, most people who were charged with that already had a very difficult time on bail. 98 and 98.1, respectively, are breaking and entering to steal a firearm and robbery to steal a firearm, which are almost never charged because they rarely come up. And when they do, they're rarely charged. Usually they'll just charge the break and entering. But I guess they've added those to the sections now. Cool. 102 is making an automatic firearm. Really doesn't come up that often. Vanishingly rare as charges go, but I guess it's now on the list. What is this going to do in terms of actual on-the-ground impact? Not a lot. It may change things in some rare cases, but it won't be often that this is what decides things. So the next thing is paragraph 515 sub 6 sub A sub 8 of the Act is replaced by the following. So, and this is where a crime is alleged to involve or whose subject matter is alleged to be a firearm, crossbow, prohibited weapon, restricted weapon, prohibited device, any ammunition or prohibited ammunition, or an explosive substance, and that is alleged to have been committed while the accused was on a prohibition order, so a firearm ban, within the meaning of Section 84 sub 1, including a release order made under this section that prohibited the accused from possessing any of those things. Now, the government has already been going around touting this section and saying this is really, an expansion of things. And I can tell you that it isn't, for two reasons. One, a prohibition order already included a release order. So basically, this is saying it's a reverse onus if you're found with a gun when you were on an order banning you from having guns. And they've now said including bail orders. But bail orders were already included. And they were actually included two different ways. They were included because they fit the definition of a prohibition order, but they're also included in another section of the criminal code. And we'll just bring that up here. So this is the section that describes the reverse onuses. So here we go. And you'll see with an offense under any of subsections 145 sub 2 to 5, that is alleged to have been committed while they were at large after being released in respect of another offense. What are those? Those are offenses of failing to attend court or breaching a court, like breaching your release order. And so if you are alleged to have been possessing a firearm in breach of a release order, you were already under reverse onus because this section says you were. So what they've done here in this new change is absolutely nothing. This, so subsection 3 of this bill has zero effect in the real world. Like subsection 1, zero effect in the real world. So far we've seen one minor effect and two things that are actively do nothing at all, ever. So, yay. We're not batting great numbers here. All right, so let's go on and look at the next bit. So, 515 sub 6 sub B.1 is replaced by the following, and with an offense, so this is more reverse onus stuff, with an offense in the commission of which violence was allegedly used, threatened, or attempted against their intimate partner, and the accused has been previously convicted or discharged under Section 730 of an offense in the commission of which a violence was used, threatened, or attempted against any intimate partner of theirs. Well, a couple of things. So what is a discharge? A discharge is that in some cases you can, instead of being convicted, they can put you on probation for a time or not, depending, but usually they put you on probation for a time, and if you successfully complete that probation, then it doesn't go on your criminal record. Okay, so they're adding that to the things that they must, that they must consider for reverse onus. This will have an effect, but again, not a huge one overall. And it's This one actually raises the possibility of constitutional questions, because this, I suspect, will get challenged as to whether or not it raises issues of constitutionality for bringing into the reverse onus provisions non-charge aspects. I suspect it's actually going to hold up. That's kind of my guess on this, but there is going to be litigation around it. The effect of it will be minor, but not nothing. Like not like those other two provisions that are actively nothing, but it's not going to be huge. And so the next thing that they're adding is, with an offense in the commission of which violence was allegedly used, threatened, or attempted against a person with the use of a weapon, and the accused has been previously convicted within 5 years of the day on which they were charged for that offense, of another offense in the commission of which violence was also used, threatened, or attempted against any person with the use of a weapon, if the maximum term of those of imprisonment for each of those offenses is 10 years or more. Okay, niche case, but the thing is that adding more reverse onus at this point doesn't really change much, because, as I mentioned, almost all of the cases that get litigated in bail court were already reverse onus, because there's just so many reverse onus provisions already that adding extra barely matters. It's going to be very hard to imagine the circumstance where this comes up, but I mean, potentially it could. But again, just so many things are already reverse onus that adding more things to that pile really doesn't change a whole lot. All right, so there is some effect on that one, but again, small. The next bit is subsection 515 sub 13 of the Act is replaced by the following: victim and community safety and security. Now, this notes, a justice who makes an order under this section shall include in the record of the proceedings a statement that the justice considered the safety and security of every victim of the offense and the safety and security of the community when making the order. So the change here is that they're adding and the safety and security of the community when making the order. So here is the thing. These statements are completely meaningless. They have put in the criminal code for some reason I don't understand or don't know, but every time they do a bail hearing, they say, and I'm going to note that I have considered the safety and security of every victim of the offense. It's really just a pointless recitation that has no value, because of course they were considering that. It's never the case that they're like, oh, I'm going to grant bail, but oh, right, I have to make this statement, and oh, right, I forgot that I have to look at victims of the offense. My bad, oops. We'll have to start over. Like, that just doesn't happen. In fact, the grounds that the justice has to consider on bail are, first, are you going to show up for court? Second, are you likely to commit another offense while on release, which, you know, raises the whole safety and security of every victim of the offense, because it includes offenses against the victim, but also against the community at large. And third, whether or not your release would, you know, basically threaten the administration of justice or bring the administration of justice into disrepute. I'm not going to get into the full definitions here because this video is already going to run long, but adding that they have to say another, what is it, 1, 2, 3, 4, 5, 6, 7, 8 more words every time they do a bail hearing is completely meaningless. It's literally just making them say a thing. It's completely pointless. Okay, so I'm adding this one to the pointless category, and that brings us back up to even for, you know, even measurements for barely does anything versus is completely pointless. The next thing is, on the 5th anniversary of which it receives royal assent, they want it studied. Okay, neat, I guess. Doesn't much matter. There's a transitional provision which just basically says how it's going to apply when it's coming into effect. And there are some coordinating amendments that don't really matter here. coming into force the 30th day after the day in which it receives royal assent. So mostly this bill is completely pointless. Most of the things that they are touting as big changes are in fact completely and utterly meaningless. And the things that do have an effect have such a small effect that, quite frankly, they're not going to be noticed in any real way. If somebody who does criminal law, like on the Crown side or defense side, didn't realize that this bill came into force and didn't realize this, it wouldn't change anything. It wouldn't, like, this wouldn't be a situation where their practice would suddenly be negligent because they'd failed to realize things changed, because the changes are so small that it won't matter. I don't think that this is going to change how defense lawyers argue their cases. I don't think it's going to change how prosecutors argue their cases. And quite frankly, I don't think that this is going to change, except in very, very rare circumstances. This won't change how bail hearings are decided. This bill is mostly just here so that they can tell the public, you were demanding the thing, we did a thing, when really they did nothing. So now I want to note, I don't actually think that the bail system is in shambles. People are saying, oh, it's, and largely what we're getting there is a lot of police propaganda, mostly. The bail system most of the time functions relatively well as government ever does. And keep in mind that everyone who is released on bail is still presumed innocent of the charges. But if they're promising to tighten things up and they're telling the public that that's what they're doing, then they're not being honest with this bill. I would have actually preferred if they'd taken a stand and said, hey, listen, we think it's fine, and so we're not doing anything. That would have at least had some courage. But nope, that's not what they're doing. So anyway, I hope you understand this bill a little better, what it does, and importantly, what it doesn't do. Thank you guys for watching. I hope you found this to be interesting and educational, and hopefully you put up with my ranting on this one. Please like this video, share it with your friends, subscribe to see more content. I also want to thank my Patreon supporters at the $50 level, CCFR, Canada's National Firearms Association, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Jane Babin Luxor. And at the $20 level, Lindsay Metcalf, Kyle Fox, Haywire, Gerald to the Bailey, Cameron Johnson, Andrew Elsich, Vicky, and Brigitte Idrup. Thank you as well to the $10 supporters who will be in the crawl immediately following. Thank you for watching. I hope this has armed you with knowledge. See you next time.